from supplementary list for final disposal attend to first appeal 37 of 2022.
This is my last order. Appellant was directed to produce the original documents. And the person who is in custody of the documents, his father is undergoing heart treatment at BM Birla, Kolkata.
He has taken the documents with him.
He has been working with the appellant for last 12 years, and since the appellant is aged about 80 years, he is completely dependent upon him for the documents.
You cannot seek adjournment without a petition.
My lord, I have obtained an affidavit from the appellant also, my lord.
I do not know what obtained an affidavit. You should have filed an application seeking adjournment on this ground. Yes. The law is whenever this interlocutory application is placed, you are bound to produce it at the time of immediately. But you are not in possession of that.
My lord, it is in the office of the appellant, and it is one Mr. Piyush Ranjan who used to look after the documents. His father is undergoing treatment at Kolkata, my lord. Because of that, we could not produce this.
Where is the interlocutory application?
My lord, I could not file it.
You file it. We will not adjourn it like this by mere saying. File it. Come in a second. File it. Oral submissions नहीं है ऐसे adjournment हो सकता.
Item 3, first appeal 196 of 2023.
Where is Mr. Sani? Respondent absent. दो चार केस डीएफडी कर देंगे तभी लोगों को समझ आएगा. पूरा कोर्ट खाली है. हाँ बताइए. कहाँ है? पास ओवर क्या शॉर्ट पास ओवर बताइए कौन सा केस हम टेकअप करेंगे.
File has not received. Mr. Rasim Kumar Sani is stuck in traffic and file is with him in the edition.
स्टेट भी नहीं है. आइए 12 बजे. 12 बजे क्या पास ओवर?
I apologize.
No, it's okay. You file your interview.
There is one difficulty in it. I must place that. The client is old and he has got an appointment in Hyderabad. He has gone to
No, that I have a.
हम लोग हमारा मुंशी कर देगा तो अच्छा.
हम नहीं जानते. कोई भी करेगा. हमें पता होना चाहिए ना किसकी कस्टडी में है, कौन लेकर आएगा. ये ऐसे बोलने से कैसे हो? Who is in custody?
Since the person could not come here, I could not get the affidavit. So therefore, I got an affidavit.
You have received instructions.
I got an affidavit shown by him.
Yes.
Locally.
And how much time do you need? Everything should be very clear.
Yes.
Because in absence of the original, even the additional evidence cannot be even considered.
I bowed down in therefore, I got an affidavit shown from him. Because I could not rely upon the oral statements. I got the affidavit.
And along with the medical documents, whatever you have to file.
Yes.
You have to file it.
I do.
Who will produce who is the person who is in custody of the documents? Everything should be there.
In fact, I had made that efforts. When I could not succeed, then I got this affidavit.
No problem. I just want you to file an affidavit.
Yes.
Such that it is in black and white that how much time do you need? Because it's a company, I suppose.
It's a company, but
it doesn't close
it's a
down.
proprietorship, but then it's a being run by a virtually a retired person in business.
Whosoever it is.
Whosoever, that's right. Matter should be placed.
You have to file your
I do.
It will come up in the second half. ऑर्डर सब चालू है.
ऑर्डर में डिफेक्ट नहीं थे वो भी उसी ग्रुप का है. प्रोविजन का सेम ग्रुप है.
कॉल करिए ना. जो दो डिफेक्ट है ना. एक तो शायद ऑर्डर्स में ही जाना था रॉन्गली लिस्टेड.
उसका नोटिस आ गया कि ऑर्डर्स में.
ठीक है. जो विद डिफेक्ट है उसको कॉल करिए. जो हम लोग का प्रोसीजर है हम लोग उसी प्रोसीजर से चलेंगे.
From daily list for orders with defect item 1, first appeal 486 of 2018.
क्या डिफेक्ट है इसमें?
डिफेक्ट ऐसे फाइल करने का तो वो ऐसे फाइल होता है. अदर डिफेक्ट कुछ नहीं था.
Who is the respondent in this case?
Yes.
Do you have any objection with regard to the substitution petition that they have filed? No objection. So far as there is one more petition. One is limitation. Other is dispensing with filing of certified.
Certified copy, that is for dismissal of the court.
That's right. Certified copy of the impugned order and supplementary order.
I can't say anything else.
Okay. So as per the procedure, if it is there on record, we are otherwise also calling for the records. Then there is no reason to dispense with that. But authentication fee they'll have to file.
Yeah.
That should be sufficient. What about limitation?
Petition was certainly able to file a petition.
You have filed any response to that?
I would like-
Have you filed?
No, I'm not ready. I got a copy of this, honestly, I will take a copy from that right now.
You don't have a copy of the limitation petition? They say copy has been served to email. Anyways, there is a delay of 1503 days. You can
It's very
respond.
long, very long, because I really, I need to file a
What first appeal of objection?
petition of counterfeit. The Union of India party and the state as well.
You have for the state?
Yes, the state.
One rejoinder has been filed by Union of India.
They must have sent a copy to the union. We don't have a copy.
How are you concerned? Compensation?
Because any acquisition proceeding, it is the state authority.
That's
state
right,
union.
but-
We are the facilitating body. So
You are the
we-
facilitating body. Then
Yes.
what objection do you have so far as the limitation is concerned? Because ultimately the payment has to come from Union of India. Any objection is primarily from Union of India, not from the state.
In any case, we find the petition for condemnation of delays.
Why have you not filed it? Why have you not filed it?
Yeah, we should have filed it by normal.
Sorry?
We should have filed it by normal.
Yes.
I admit one.
It's
If
just
permitted, I will tell otherwise. On the basis of the counter filed with the union can be disposed of.
You see, so far as the interlocutory application regarding substitution, regarding exemption, these two we will take care of, right? So far as limitation is concerned, the reply of Union of India is there. In other cases also, Union of India has responded. So, other matters are under the heading for orders, which will be taken up at 4 o'clock. So, I will pass an appropriate order with respect to the interlocutory applications which they have filed, because of which it is defective. And then we will condone the delay also and call for the records and fix a date. Simple.
But in the matter of condemnation of delay, now it is one of the Supreme Court is one of the strict policies. So
In land acquisition
even
matters,
in such matters,
you have to cite judgments.
sufficient reason has to be shown in circumstances. It cannot be the discretion of the party to come to the court of law at any point in time and say that limitation should be condoned.
They have said that they did not have money, but once the order has been passed by this court, exempting them from payment of court fees, then they have moved this court. So, appears to be a genuine reason, isn't it? Yeah, these are
You
two.
can
Come in the second half because rest matters are also coming
at 4.
at 4. We'll take up these matters at 4 and pass a separate order for this. Mr. B.B. Kumar is also not there, so I was just wondering. He will be there at 4. 10. 4.
For hearing under order 41 rule 11, item 14, second appeal 190 of 2020.
Where is the appellant? Okay. SA number 190 of 2020. Nobody appears on behalf of the appellant. Wide order dated 10/9/2024. The prayer for adjournment was allowed, subject to deposit of cost of ₹1,000. Thereafter, when the case was taken up on 9/1/2025, again an adjournment was sought without prior intimation to the court. which was subject to payment of ₹5,000. Today, when the case is called out, nobody is appearing on behalf of the appellant. ये 2:15 का टाइम है इसका. हाँ?
16 तारीख को
Where is the appellant? I don't want to. Lalit Yadav. He is a counsel for the state also. हाँ? सेकेंड अपील ऐसे डिसमिस कर देंगे ना, रेस्टोर नहीं हो पाएगा. ये इतने सारे रिस्पोंडेंट्स हैं इसमें. You know him? Do you know him? आज कोर्ट बिल्कुल खाली. आज हम 10-20 केस डिसमिस और डिफॉल्ट करने वाले हैं. Those people who will not come, right? I'm making it very clear. यहाँ पर ऐसे नहीं हो सकता. Cases are being listed for hearing and nobody is interested in hearing, and they will say that the case is not being taken up in the high courts. Yes, we will not take this. The case is pending because of advocates, not because of the judges. Those who will not appear, I'll dismiss the case. Surely. Since the appellant is not appearing, since counsel for the appellant is not appearing, and no advance notice seeking adjournment has been circulated, this appeal is dismissed for non-prosecution till the case will come.
For hearing item 50, second appeal 240 of 2018.
नाम फ्लैश करिए इसका. हम लोगों का जो भी फाइनल डिस्पोजल के लिए मैटर्स फिक्स हुए हैं, उसका जरा अंजलि से बताइए किस दिन कितने केस फिक्स हुए हैं. Yes, argue your case. Yes. Who is appearing for the respondent? Has anybody entered appearance?
Yes,
Who? कौन किसका नाम appear कर रहा है इसमें? Get your file.
Is an idea for stay. I was just praying that maybe
No stay. We are for final dispute.
maybe not final next week.
Next week you seek adjournment. IU will be dismissed. Because you are seeking adjournment, the case is ready for right for hearing. Record आ गया है ना? When the case is right for hearing and the court is ready to hear the matter, where is the question of any stay?
So I'm not pressing stay.
So
I'm
you,
just saying
you don't
that
press
maybe
it.
it will be heard by
Yes. When do you want?
next week.
Like 240 of 2018. There are many IAs pending. How many IAs are pending? is also for interim relief. There are 2 IAs for interim relief. बताइए, आपके पास फाइल है कि नहीं है, ये बताइए.
Fine, yes.
फाइल तो खोलेंगे ना कम से कम. I'll give you time. Let us start the hearing. सेकेंड अपील ऐसे नहीं, फैक्ट्स वगैरह देखेंगे, थोड़ा समझेंगे क्या मैटर है. एक दिन में नहीं होगा.
Yes.
And then we can post it on any other day so that we are also ready. Where is your file?
215 minutes.
आप तैयार हैं? आपका फाइल
मेरा फाइल तो टेबल में रखी है।
कहाँ रखी है?
बाहर में रखा हुआ लेते आ रहे हैं हम कॉल और दौड़ के कोर्ट में आएंगे। फाइल आया हुआ है
फाइल आया हुआ है
जी।
ना? तो भाई इसको करिए, ऐसा नहीं करिए. देखिए अब सेकेंड अपील का हियरिंग बेंच चल रहा है,
जी
ठीक है? अब हम हियरिंग करेंगे.
जी हम लोग
ये सब्स्टिट्यूशन और इंटरलोकेटरी एप्लीकेशंस में हम अपना लाइफ नहीं बर्बाद कर सकते
जी
रेस्टोरेशन में. इसीलिए वो 4 बजे ऑर्डर, सब 4 बजे आराम से 4 बजे तक रुकिए, अपना सब्स्टिट्यूशन और जो करना है.
हमारा प्रेयर हो जिसको नेक्स्ट वीक
नहीं, हम देंगे आपको टाइम. लेकिन लेट अस ओपन द ब्रीफ,
जी
find out what are the concludes,
Lots.
what is the case of respective parties. Let us see what is the question of law framed, understand it, and then I'll post it on the list. ऐसा ही करना ठीक है. हम एक बार में एक दिन में सेकेंड अपील जल्दी से डिसाइड भी नहीं करते ऐसे,
ठीक
ठीक है? तो समझने में भी टाइम लगता है, ठीक है? नेक्स्ट वीक हम लोग का कौन सा दिन से शुरू हो रहा है? 27 को रखेंगे. 27 को एक भी केस हम फाइनल डिस्पोजल में नहीं रखेंगे. सॉरी,
Any other date?
बाय
27 minutes.
29th,
20.
ठीक है? आज हम लोग शुरू करेंगे इसको,
जी
29th को फर्दर है.
जी
Yes.
That's the understanding.
Yes.
जी
And after hearing in the second half today and finding out the contours of the case, you will also prepare your short synopsis
Yes.
depending on our queries, such that the case is ultimately disposed of in the next
लो
day. Done? Record आ गया है concurrent findings. सवा 2 बजे. There is one more case fixed at 2:15. It will be taken up only after that.
After.
Item 16, second appeal 382 of 2018.
You can't put every case in the second half. No, you start your hearing. You
So
start.
it has to be argued on the
He has asked you not to open your file.
It has
as-
to be argued on questions of law that has been
Sorry?
framed.
Yes.
It has to be argued on the merits.
Certainly so. You are not qualified to argue on the merits.
I'm just praying that it may be taken in the second half.
Many
So that
cases. See, all cases cannot be fixed in the second half. Where is your file?
I have the file.
Where is it? Where is your file?
I have the file. So I'm just praying that it may be taken in the second half. Because the questions of law have been framed by order number
All right.
6.
Your senior will come.
In the
You have been
second-
instructed to seek adjournment for the second half. I will not adjourn it further. Remember that. I will not give further passover.
in the second.
इसको भी कर दीजिए. Respondent कौन है इसमें? चलिए second half this one.
Item 17, second appeal 503 of 2018.
Where is the state? This is the state's appeal. Mr. Amit Kumar Verma is the advocate on record, but it is an appeal by the state. Are you the state counsel? Where is your counsel? Should we dismiss it?
Just inform.
Mr. Amit Kumar Verma, right? Inform him, ask him to come. Over to him. एक राउंड पास ओवर करेंगे, उसके बाद सब केस डिस्कस करेंगे. ठीक? Ask him to be here.
Item 18, second appeal, 88 of 2019.
Please for the applicant. His junior was here right now. Naam flash karo. Your case has been called out. पास ओवर हम आपका करेंगे. बताइए कौन सा केस हम टेकअप करेंगे. फाइल को लिए फाइल. ऐसे पास ओवर नहीं. Therefore you go through the file right now along with me. Open your file. जो लोग घर से फाइल नहीं पढ़ के आएंगे उनसे यही पढ़वाएंगे पूरा टॉप टू बॉटम, कवर टू कवर. Yes, open your file. See the substantial question of law. Framed by order dated 13/5/2019. Yes. अगर आपका क्लाइंट इस वीडियो को देख लिया तो वो क्या सोचेगा? Have you ever thought of it?
Yes.
You should be conscious of
Other
it.
junior has seen the file.
Other junior, जो भी junior फाइल देखे उन्हीं को बुला के लेके आए.
That's why
Who is that junior who has seen the file? Who is that junior who has seen?
I just I'm not.
नाम तो बताइए.
I have not seen that. Yesterday I have not seen this file. This is difficult for me.
इतना chaos आपके चेंबर में रहेगा तो कैसे ही हो? चार्ट बनाया करिए. कौन सा केस किस जूनियर का लॉक करके?
एक पासवर्ड है. नेक्स्ट इज
जो गूगल फॉर्म नहीं रखते आप लोग?
रहता है मैडम लेकिन लॉटशिप बट एट प्रेजेंट आई हैव नो इन्फॉर्मेशन हु हैज सीन दिस एट.
अच्छा रिस्पोंडेंट को सुनो. ठीक है, बुला के लेके आइए. यस रिस्पोंडेंट, व्हाट इज द केस यू टेल अस? यू आल्सो वांट सो शॉर्ट पास ओवर.
By mistake.
ये सारे वीडियो सर्कुलेट होना चाहिए.
By mistake, the clerk kept the file in some other court.
कौन सा कोर्ट है जो इस कोर्ट इस प्रेमिसेस के बाहर?
नहीं, इसी premises में. That's why in another case also mine was. But it is a landlord-tenant dispute matter. The substantial question of law was framed in 2019. I was the landlord, they have lost in both the courts.
I want people to see the videos and find out who is a good counsel. Right? Because advocates cannot advertise themselves. People would see the video and find out, yes, ये वकील बढ़िया बहस करते हैं, है नहीं?
We have read all these files, but the only problem
वो
is
आगे बहस करें. अपना फाइल मंगाइए, मुंशी को फोन करिए. Have you prepared the file, I suppose? Yes, come on. फाइल मंगाइए, फाइल मंगाइए. She was here.
yes, of CS.
चलिए पढ़ी. आगे. आराम से बैठ जाइए. पानी नहीं रखते हैं आप एडवोकेट्स के लिए. हाँ, पानी पिलाइए उनको. ऐसा मत बोलिएगा कि जज साहब पानी पिला के बहस करवाते. Give us some water. You sit for a while. Sit down. पानी दीजिए उनको. CPC नहीं. CPC.
My apologies, I mentioned. Your Worship, in this matter,
Had some water.
thank you very much. Your Worship, in this we have challenged the impugned order that is at page 36, Your Worship. Coming to the facts of the case, Your Worship, in this matter, the appellant, who is Ashok Kumar Gupta, an execution petition was filed by the respondent, who is Nirti Lal. That execution petition arose out of a partition suit, wherein the said allotted land was allocated to her share. A writ of delivery of possession was issued, Your Ladyship. Pursuant to that, a notice was issued to us to vacate the land premises. That is when that is when the appellant found out
You are
about
you were a
objector.
party in the partition suit.
Your Ladyship.
You are a third party.
Yes, Your Ladyship. We were a third party only after getting knowledge of the fact that such an encroachment is existing. We were issued notices, and then thereafter we filed an application before the learned court below under order 21, Rule 97 and 99. So, Your Ladyship, that particular application was rejected summarily without granting us any opportunity to lead evidence, Your Ladyship. Our claim is that for 50 years we had been on land. Our forefathers had already constructed a house, and we had continuously been in possession for 50 years. But we were not given any chance to present any evidence to that effect, Your Ladyship. And summarily, the learned court
By saying what?
Yes, Your Ladyship.
Uh,
I may draw your attention to the
Now,
first one.
now please enlighten us how a petition under order 20. This is 40.
Order 21, Rule 97 and 99.
What is the mode and manner in which it is released?
So when we permitted
This is
to read
order-
the sections 21,
21 rule
97 and
97 and 98.
Rule, yes, 99.
97 and 98.
Yes, Your Ladyship.
Okay.
If I may be
Yes.
permitted to read, Your Ladyship.
Yes.
Rule 97, Order 21, resistance or obstruction to possession of immovable property, whether the holder of a decree for the possession of immovable property or the purchaser of any such property sold in execution of a decree is resisted or obstructed by any other person in obtaining possession of the property, he may make an application to the court complaining of such resistance or obstruction. Where any application is made under sub-rule 1, the court shall proceed to adjudicate upon the application in accordance with the provisions of law herein contained. And thereafter, 99. Dispossession by decree holder or purchaser, where any person other than the judgment debtor is dispossessed of immovable property by a holder of decree for the possession of such property, or where such property has been sold in execution of a decree by the purchaser thereof, he may make an application to the court complaining of such dispossession.
But you have not been dispossessed.
We have not been dispossessed, but we were given a notice to remove the
But
encroachment.
it says that where the judgment debtor has been dispossessed.
Yes, Your Ladyship, but further it also says where any such application is made, the court shall proceed to adjudicate upon.
That's right. This is post disposition.
Yes, Your Ladyship.
Prior to disposition, what is to be done?
We had filed an application under these two sections, Your Ladyship.
What
These-
about 98?
Yes. Order after adjudication.
Yes.
Upon the determination of the question referred in Rule 101, the court shall, in accordance with such determination and subject to the provisions of Sub-Rule 2, make an order allowing the application and directing that the applicant be put into possession of the property or dismissing the application, or pass such orders as in the circumstances of the case it may deem fit. Sub-Rule 2, where upon such determination the court is satisfied that the resistance or obstruction was occasioned without any just cause by the judgment.
That's right.
debtor.
So 98 is the adjudication,
Yes.
and 101
101 talks about
is the
questions.
questions to be determined, right? So read 101.
Yes. All questions, including questions relating to right, title, or interest in the property, arising between the parties to a proceeding on an application under Rule 97 or Rule 99, or their representatives, and relevant to the adjudication of the application, shall be determined by the court dealing with the application and not by a separate suit for this purpose. The court shall, notwithstanding anything to the contrary contained in any other law for the time being in force, be deemed to have jurisdiction to decide such questions.
Read 102.
Rules not applicable to transferee pendent litigation. Nothing in Rule 98 and 100 shall apply to resistance or obstruction in execution of a decree for the possession of immovable property by a person to whom the judgment debtor has transferred the property after the institution of the suit in which the decree was passed, or to the dispossession of any such person. 103 is also relevant.
Yes.
Orders to be treated as decree. This is our main ground. Where any application has been adjudicated upon Rule 98 or Rule 100, the order made thereon shall have the same force and be subject to the same conditions as to an appeal or otherwise as if it were a decree.
So basically, you were supposed to you were entitled to adduce evidence in respect of whatever claim you had,
Yes, Your
and that claim was required to be adjudicated.
Yes, Your Worship. The execution court has that power.
It has that power because third-party rights are also
Yes,
involved, who was not a party to it.
Yes, Your Worship.
So you filed the petition while in possession.
Yes.
So 99 does not apply, 97 applies.
Yes.
And any adjudication would have the force of decree,
Yes.
and therefore you filed your first appeal, and therefore the second appeal.
It is maintained.
Okay, let us see that what is the reason for not adjudicating any. Now you refer to the question of law. Now you refer to the question of law.
That is framed by this court. Your Worship.
That's right.
This court.
13/5/2019.
Whether the learned court below has committed an error by not adjudicating the case.
That's
on
right.
merit.
This is the sole point.
Yes.
Yes. What do you say?
There has been an adjudication.
There has
Is
been
there-
adjudication.
Yes, they are claiming their right only on the basis of possession. They have not submitted any sheet of paper
Need
to show
not.
their independent.
Need not.
Yes.
They may claim any kind of right.
Yes, so they are claiming their right only on the basis of possession. But however, at the time of execution, the pleader commissioner in his report has submitted that they were never in possession. In fact, they had encroached upon the property during the pendency of the execution proceeding.
So therefore,
Yes.
is there any finding to that effect?
Yes, there was.
That they entered into the property during the pendency of the execution?
Yes, the pleader commissioner has submitted in his.
Pleader commissioner has submitted a report at that stage of execution, or he submitted a report at the time of partition.
At the time of partition.
So any report which has been submitted at the time of partition is not binding on third party.
Yes, but for the purpose of.
No, is it binding on third party?
It is not binding. on-
They are not party to it. So that particular report cannot be taken into account to decide this particular issue. Had they been a party, we understand. So whatever be their right, and whatever be their source of possession or whatever, they have been in possession for last 50 years. They may claim anything, but can it be rejected on the ground of the report of the pleader commissioner? No. Tell us.
It has not been rejected only on the ground for the purpose of 21, 97 and 99. what they have to establish is they are claiming an independent right from what the judgment debtor
They
had.
have right to.
Yes.
They have right to claim independent right,
So if-
and that right is required to be adjudicated.
So that independent right was never established, because if they are claiming a right through the judgment debtor itself, or judgment debtor himself, then there is no question of application of
They are
that
not
right.
claiming any right through the
Yes.
judgment debtor.
So it was onus of
एक सेकंड दिखाइए सर LCR है. Let us read the judgment. I am not able to lay my hands on that petition. It must be mentioned in the judgment itself. You read the judgment. The
order dated 3/12/2018. The
yes,
first
the first judgment. Can you read it?
The
Page
operative
27. No, not the operative.
Part, yes. Attendance has been filed by
No, next part.
the
Order.
learned lawyer for the petitioner has submitted that the present execution case has been filed by Tripti Lakan on the basis of alleged allotment claimed to have been made in her favor in a decree of partition entitled partition suit number so and so. The execution which has been instituted with respect to alleged allotment having area of 27 feet 9 into 9 feet 2 inches so and so in possession of the petitioner as reported by the learned legal commissioner. It further submitted that it is pertinent to mention here that in the allotment chart of the pleader commissioner attached with the final decree, the decree holder has been allegedly allotted open plot measuring 19 feet into 8 feet, which is only 152 square feet. The measurement submitted by learned pleader commissioner in execution case number 2016 is erroneous. The area claimed to have been allotted in favor of the decree holder is in actual physical possession of the petitioner since the lifetime of his father, approximately about more than 50 years. The alleged area is attached with the residential house of the petitioner over survey plot number so and so, corresponding to Chaibasa Town Khas Mahal holding number so
He
and so.
claimed adverse possession. It was required to be adjudicated. Where is the finding?
Finding is at page.
Let us see their case. Let us see their case at page number 30.
Your Lordship, the
The learned
opposite
lawyer
party
for the
is-
decree holder.
Yes. The learned lawyer for the decree holder opposite party has submitted that the petition filed by the objector is not maintainable. The objector has not yet got an opportunity to resist the decree under execution, hence the petition filed by the petitioner is liable to be rejected outright. The settled proposition of law is that resistance must be actual destruction. The objector has no locus standi to put any objection or file any petition under any provision of law. It is further submitted that not a single ingredient to invoke the provisions of Order 21 Rule 9799 of CPC has been made out. The petition of the objector is entirely frivolous, baseless and untenable in law. The objector has not impeded the other judgment debtors in ambit of the petition, though they are all necessary party. The objector has not read out the allotment chart and other
The
documents.
entire petition has been decided on the basis of whatever transpired in the partition suit. It was required to be identified. You tell us when do you want the date to be fixed. You tell us what is your case. Let us hear it. Any proceedings in the partition suit will not bind them. If their claim of adverse possession may be in the realm of claim, was required to be adjudicated and they were supposed to be evidence. बताइए कब का डेट रखते हैं आप दोनों जने appear कि next week नहीं दोनों जने appear होकर वहाँ पे adjudicate कराएंगे हम ओके सुन लिए ना अब क्या सुनना बताइए You have seen you have love में 5 साल हो गया 10 साल हो गया कितना साल हो गया 5 साल हो गया 5 साल हो गया 4 साल आप कॉलेज में भी थे you were such a good student 5 plus 4 9 years practicing exclusively on civil side correct you have a very seasoned senior so इतना background तो आपको पता है आपके बारे में इसीलिए इसको पढ़ने के बाद अब क्या बोलना है you want to call you senior
He is not here. That is it.
उसका उनका कोई जरूरत नहीं you argue whatever you want
This also may be kept at.
डेट भी सोच के आइएगा कौन से दिन आप लोग अपियर होइए
Item 19, second bill 157 of 2019.
yes
Serial 17 was small, my lord. I'm sorry, but file has been misplaced. Every week, the case is being listed, my lord. It will be found out, my lord. Next week, कभी भी नहीं. Serial 17.
सीरीज 17 में क्या किया
एक केस में
पास ओवर हुआ है केस के लिए आप हैं इसमें
19 में
रुक जाइए एक सेकंड 17 का कहानी अभी खत्म
17. मतलब फाइल मिल जाएगा मेरा. कहीं इधर उधर हो गया है. नेक्स्ट वीक कभी भी नहीं.
आप लोग समझ नहीं रहे हैं आपका ये सारा सबमिशन जो है इट इज परमानेंटली रिकॉर्डेड और आपका लिटिगेंट सुनेगा कि आपका फाइल मिसप्लेस हो गया उसको तो हार्ट अटैक हो जाएगा
नहीं नहीं हाँ बेटा.
स्टेट को तो हार्ट अटैक नहीं होगा
इसीलिए बोल रहे नहीं होगा. लेकिन फिर भी मारो नेक्स्ट वीक करो बेस्ट. ऐसा होता नहीं है लेकिन हो गया.
बिना कॉस्ट के नहीं है जज
नहीं
नहीं एज पर द प्रीवियस रिजीम बिना कॉस्ट के नहीं है नो टोकन कॉस्ट तो देना पड़ेगा सरकार को क्या है एक पॉकेट से दूसरे पॉकेट में जाएगा क्या ही फर्क है बताइए फर्क है नहीं फर्क है ना सरकार को क्या फर्क एक पॉकेट से दूसरे पॉकेट
नेक्स्ट वीक
आई विल डू इट देखिए रिस्पोंडेंट कौन है इसमें अमर कुमार सिन्हा आपका है रिस्पोंडेंट इस केस में आप हैं संदीप वर्मा मिस्टर अमर कुमार सिन्हा आर यू देयर इन दिस केस फॉर द रिस्पोंडेंट्स आपका क्या नाम
सीरियल 17 SA 503
आप तैयार हैं आप तैयार हैं देखिए यही ऐसा कोर्ट है जहाँ जूनियर लोग को मौका मिलेगा बहस करने मतलब बाकी जगह भी मिलता है लेकिन यहाँ तो जरूर मिलेगा आप लोग फाइल नहीं खोलते हैं अगर जूनियर सिर्फ टाइम मांगेंगे तो उनमें और उनके क्लर्क में क्या अंतर है वैसे तो उनका क्लर्क भी आके बोलेगा टाइम चाहिए तो हम दे देंगे तो जूनियर की कोई जरूरत नहीं है जूनियर शुड बिहेव लाइक एन एडवोकेट नो फाइल आपको नहीं मिला है आपको भी फाइल नहीं मिल रहा है यही लिखा है आपका फाइल मिसप्लेस हो गया है यस
नहीं ऑफिस पे ही है.
ऑफिस में
इस साल का उस साल पे रखा गया है बस यही हुआ है.
essay number 503 of 2018 learned counsel for the parties are present the learned counsel for the appellant prays for adjournment no advance notice seeking adjournment has been circulated however for the ends of justice. The matter is adjourned and is directed to be posted on 27th. 27th. Correct? 27 तारीख. On 27th of January 2025, under the heading for final disposal to be taken up at. It is made clear that no further adjournment will be granted. अपना appearance दीजिए, अपने senior का नहीं अपना.
Item 19, second appeal 157 of 2019.
Yes.
In this case, no time frame, but it may be fixed on 2:30 on 6th. On that day, we will not ask me anything. But it will be
Fixed on which date?
6th 2:30 में fix कर दिया जाए, हम लोग को उस दिन कर देंगे.
देखिए by way of last chance already हो चुका है.
और
बिना एक बार हो चुका है ना by way of last
एक चीज
chance.
खाली हम करें, रेडी नहीं हुई इसमें बहुत इसको 6th को फिक्स कर दिया जाए. सामने वीक में हम करवा लेते हैं, लेकिन हम नहीं रहेंगे. मेरा बाहर जाने का
6 को कर देंगे, लेकिन there is a judicial order by way of last chance, तो उसका हम क्या करें? उसको इग्नोर कर दें?
नहीं,
Then कॉस्ट के साथ करेंगे. 6 को रख देंगे.
इसमें नॉमिनल पोस्ट अगर करना चाहिए तो नॉमिनल कर दिया जाए.
Nominal according to is how much?
500.
Essay number 157 of 2019. Learned Counsel for the appeal and seeks adjournment. The matter was adjourned on 27/4/2023 and prayer for time was allowed by way of last chance. Today he is seeking adjournment, but no advance notice seeking adjournment has been submitted. He submits that the matter be posted on 6th.
6th February.
6th. Post this case under the heading for final disposal on 6th of February, subject to payment of cost of rupees 5,000 to be deposited in
500, not 5
the.
hours.
Oh, sorry, 500 to be deposited in the Association of the Advocates Club. क्या नाम है लिख के दीजिए.
Item 20, second appeal 188 of 2019.
फाइल कहाँ है? फाइल है ना? शुरू करिए, हम एडजर्न कर देंगे. शुरू करिए. क्वेश्चन ऑफ लॉ से शुरू करिए.
This is a
Read the question of law.
page number 4 in my question of frame which we admitted second appeal.
6/8/2024 के ऑर्डर से क्वेश्चन ऑफ लॉ फ्रेम हुआ. 6/8/2024 का ऑर्डर पढ़िए. नहीं है आपके पास?
Copy नहीं.
क्यों नहीं है? Why? It is an uploaded order.
Question is whether the learned first appellate court, being the additional judicial commissioner to Ranchi, has committed a perversity by holding the armed land cannot be settled to anybody, being contrary to the settled principle of law as has been held by the Honorable Patna High Court in the case of Muhammad Hassan versus State of Bihar, reported in 1970 PLGR 7, and which was retired in the case Maya Devi versus the State of Bihar in CWJC number 1623 of 2023, dated 28/3/2024. As also the case of Chandeswari Prasad, Narayan Dev and others versus State of Bihar and others, reported in 1956 BLJR 24. As also in the case of Lakshman Shahi and others versus State of Bihar and others, reported in 1991 BLJR 457. Second, whether the learned first appellate court committed perversity by not considering the plea of adverse possession of the plaintiff on the ground that the same can only be used as a seal and not sword, in view of the principle of law settled by the Honorable Supreme Court of India in the case of Ravindra Kaur, Derival and others versus Manjit Kaur and others, reported in 2019 SSC 79.
Was any plea of adverse possession, was any issue of adverse possession framed by the learned trial court? Yes?
going to para 17. From the point of learning township court, the appellant has argued that the being possession on the said land for more than 30 years since 1932. Protection of adverse possession has acquired in their favor, but I am unable to agree with such agreement on the fact that now it is settled that the right of adverse possession can be used as sale but not as the stone, meaning thereby that the plaintiff cannot get decree in a suit filed on the ground of adverse possession, rather it can be used as decree in suit if any. Therefore, such ground of argument are not acceptable in the line of law. Since only above consideration of law, it can be safely held that Amgandiwa land cannot be settled or cannot be in a rightful title position of any individual, which is only meant of public purpose, irrespective of any kind of possession for any period. In this case, in particular, for personal possession is mentioned in the petition of person being confused in such possession for any period in any manner can only be treated as illegal possession or pursuit possession which cannot have.
Where is the finding recorded by the learned court that because it is Gair Majurba arm land, it cannot be settled? Where is that finding? And the nature is of that of Sarna land, which is public land. There are two reasons. There are two reasons. Gair Majurba arm land and nature of land is Sarna land, which is public land. Sarna land can be settled. That is not the only reason that it is Gair Majurba arm land. It is further writer that the nature of land is Sarna land, which is public land. नहीं समझ रहे ट्रायल कोर्ट बोला that you are claiming adverse possession as and also title over the property by virtue of registered deed, which is conflicting, and such a contrary stand cannot be permitted to be taken so far as adverse possession is concerned. That is a correct law, that if you are claiming any property by virtue of a deed, a title deed, you cannot have both the things simultaneously. These are conflicting. है ना? So even if it is used as a short or sealed, your case for adverse possession is not made out at all. The finding is not just Gair Majurba arm land. उसमें आधा वो वाला जो आधा सेंटेंस था दैट इज सरना लैंड, वो उसमें नहीं है. उसके लिए हम लोग कुछ नहीं जानते. आपको सुन के ना सब्सटेंशियल क्वेश्चन ऑफ लॉ फ्रेम हुआ है. और ये जो जजमेंट्स हैं रेयती लैंड अगर गायर मजूबा आम है तो उसका सेटलमेंट हो सकता है, लेकिन सरना लैंड है, वरियल है, इस तरह के का लैंड का सेटलमेंट कैसे होगा बताइए. चलिए कब करना है, आपको क्या बोलना है?
Procedural not received the copy of the appeal. The case is coming
बहुत अच्छी बात है.
it's coming for the first time after the file of that.
So what were you doing? अभी 15 मिनट से क्या कर रहे हैं? Waiting for us to ask you a question. Yes.
2 weeks time में again we'll be ready to
2 weeks time नहीं दे सकते हम सुन लिए हैं. आप इनको दे दीजिए मेमो ऑफ ऑफिस डॉक्यूमेंट. इतना टाइम नहीं दे सकते. बताइए नेक्स्ट वीक कब करना है? 28.
28 के बाद वो आ जाएगा 29 से
29th. करेक्ट?
30 को
30 तारीख को रख देते
30
Essay number 188 of 2019. Learned counsel for the parties are present. From the perusal of the from the perusal of the trial court judgment, which is apparent that in the record of rights the land was registered as Gair Mujurba Arm land and nature of land is Sarna land. The learned counsel for the appellant has placed the infringed judgments and has submitted that and has sought adjournment by submitting that further arguments will be advanced by his senior counsel. Pose this case for further argument under the heading for final disposal on 31/2025 to be taken up at 2:15. It is made clear that no adjournment will be granted on that date.
Appearance दीजिए appearance. Item 21, second appeal 304 of 2019.
Seeking adjournment on behalf of Mr.
On behalf of Mr.
Arun. He is one of the member of the election committee member.
So when do you want?
Not today you want. जब आप
Tomorrow?
not today मतलब फिर कल
Not today मतलब अगले सप्ताह ये कौन सा लैंग्वेज है?
अगले सप्ताह मतलब not today.
Not today मतलब tomorrow ही होता है.
Pass over for the day जो है कल आता था. Not today.
Pass over for the day में भी tomorrow ही होता है.
Next week.
क्या क्वेश्चन ऑफ लॉ क्या फ्रेम है?
There is one on limitation and another has been framed on the effect of death of two of the defendants. Two questions of substantial question of law by order dated 1/3/2023, order number 7.
And you did it.
Whether the suit inter alia filed with a prayer for declaration of settlement deed bearing number 1469 dated 3/11/1947 executed by Rajkishore Nand in favor of Dhando Kharia is barred by limitation as the suit with such prayer was filed on 1/8/2023 in view of the principle of law settled by the Honorable Supreme Court of India in paragraph 19 of case of Abdul Rahim and other versus Sheikh Abdul Jabbar and other.
What is the case of Abdul Rahim?
Abdul Rahim was a case, my lord, where there was a gift by a Muslim, my lord, hiba, that was sought to be challenged by the person who had earlier challenged it in mutation proceeding, and then he sought to challenge it beyond 3 years from his knowledge. So in that view of the matter, the Honorable Apex Court held that since he was a party to the mutation proceedings, revenue proceedings, he was having knowledge of it, so he could not have assailed it beyond a period of 3 years from his knowledge. That was perhaps 67 or something, it was an old deed. So that is one, but that is where I will seek to distinguish matter of that judgment.
So if the point of limitation is decided, let us assume for a moment against you. If it is decided against you and it is held to be barred by limitation,
Yes.
then the second question becomes redundant.
Yes.
Correct?
Yes, true, man. Once the suit was held to be not maintainable, everything goes, the degree goes, everything goes, anything in my favor. By operation of limitation, my right will extinguish. Even though if I had a right, assuming it extinguishes by limitation.
What is the point number 2?
Point number 2 is two defendants, my lord.
Let us kindly read it.
Yes, ma'am. Whether the learned First Appellate Court committed a perversity by not taking into consideration that the judgment and decree passed by the learned prior to in title suit number 29 and 2003 is against two dead persons, being the defendant number 2, Kupi Ahirin and Taramuni Devi, having been died during the pendency of the suit, and the judgment and decree passed in title suit number 29 of 2003 is a nullity in view of principle of law settled in paragraph 6 of case of Kishun alias Ram Kishun, dead through legal representative versus Bihari, dead by legal representative, reported in 2005 volume.
What do you say to that?
Lord, I will make two full prayers. First, that I will make is after filing of the written statement, the legal heirs cannot take a contrary stand. Second, the legal.
It is not a matter of taking contrary stand.
Once the
Somebody has died during the pendency of the suit. Then, under such circumstances, what is the consequence?
My lord, the law requires that the counsel representing them should inform in writing to the learned court that such and such person has died, and then the plaintiff is duty bound. From that date, within 90 days, he has to substitute the legal.
The reason for non-substitution, has it come on record?
My lord, the first.
Has it come on record that you had no knowledge?
But that issue, the court has framed the issue that this issue was not at all considered. Not at all considered that they had died. This was not, issue was not formulated and not considered. This is what is the substantial question. So I will try to defend my lord. Second, on that, the other sub-ground I will take is, my lord, that all the defendants, when the right to sue would have not survived, then the suit would have failed. This is the second sub-ground that I urge, my lord, before when it is heard, to defend that point. But the question.
Okay. Essay number 304 of 2019. The learned counsel for the parties are present. The counsel for the appellant is seeking adjournment and is submitting that the matter be posted next week. The learned counsel for the respondent has referred to the order dated 1/3/2023, by which two substantial questions of law were framed. One was relating to limitation and the other was relating to abatement.
Yes.
We have submitted that the point of limitation, if decided in favor of the appellant, utna mat likhiye. Considering the prayer of adjournment made by the counsel for the appellant, close this case for final disposal on. कहाँ वो चार्ट कहाँ चला गया यहाँ से? ये 29th. It is made clear that no further adjournment will be.
Or 18 from 30.
आपके choice से date नहीं होगा. Next case.
Item 22, second appeal 031 of 2019.
Please, appellant.
July 23.
Yes.
Question of whether the London First Appellate Court committed perversity considering that the recital made in the registered settlement date not executed are a conclusive proof of title of the vendor of the title. And also there is a judgment of reversal.
Yes. Let us see the trial court judgment.
One paragraph that is summarizing the entire case. Paragraph.
We will go through the judgment.
Yes.
What was the relief paid? Declaration of title.
Declaration of title, recovery and possession.
Yes.
Trial court judgment, paragraph 22.
What were the issues framed? What was the basis on which you were seeking your declaration? Was there any salient in your favor?
They said that
You are the plaintiff or the defendant?
I am defendant.
Oh, defendant is
I am
the
the
just a moment.
successor of,
Yes.
I am the successor of recorded tenant one Bhagirath Molla, who was the recorded tenant. Land was settled with him. Now, defendant of the successor of Bhagirath Molla.
Bhagirath?
Molla.
Yes.
The event says that they are the successor of recorded tenant. They never failed in payment of rent. They continued as a tenant, and even the record of right also shows that they are still holding as a tenant under the state and paying rent to the state.
That's
Now, plaintiff said that one Uday Karmakar took settlement from the Raja by registered deed of settlement. This recital of the deed says that there was this Bhagirath Molla defaulted in payment of rent. So the rent suit was filed, that suit was decreed, then it was put in execution. Now in execution the property
so
was
these factum narration in the recital in the same deed was taken into consideration.
Yes. Only taken into consideration the supporting document.
When not
because
produced?
None of the document is produced. That is the trial court finding at page.
Just a moment. Let us see the case of the plaintiff.
Yes.
Did he refer to all this? All these execution cases and all?
Para 2 of judgment you will also cover.
Yes, para.
Plaintiff have claimed following reliefs on the basis of that land recorded under CS file number 42 of Moja Dumri, PS so and so, including Schedule A land, was the recorded land of one Bhagirath Molla, held in Raiti Rai on a rent of rupees so and so, held under the landlord Raja Shivaprasad Singh Rajat Kichharia Raj State. That as the rent fell in arrears, the landlord filed rent suit and obtained degree, and the execution case number so and so said holding was auctioned, sold and purchased by the degree holder on 15/2/35, and after the said auction was confirmed on 18/3/35, and thereafter the landlord Raja Shivaprasad Singh obtained delivery of possession of the said holding measuring 2.91 acres on 14/9/36, and since then remained in khas possession of the landlord, that while thus in possession Raja Shivaprasad Singh by registered patta number so and so dated 23/2/39 granted settlement of 66 decimals of land of plot number 1994 4 decimals and 62 decimals of plot number 1995 as delineated in the plain annex to the deed to Uday Karmakar of Dumri in permanent occupancy right on receipt of Selanga rupees 24 and reserving annual rent of rupees 2 besides sales and delivery of possession to him.
that since the date of settlement, the said Uday Karmakar remained possession of the said settled land and cultivated the same, enjoying the usufruct on payment of rent to the landlord, and after vesting of Jharkhand estate in 1951 to the state of Bihar, and after his death, the plaintiff are in peaceful possession thereof. The manner aforesaid, plaintiff number 1 has also bid to brick pit, tiled roof, shops room by the side of the road or in or about 1986, and let out to tenants from time to time.
These facts were totally disputed in the written statement.
Yes.
These facts which were narrated in the plaint,
Yes.
except that the recorded tenant was this Malla,
Ah.
everything else was disputed in the written
Yes.
statement.
Yes.
Now let us see the finding of the learned trial court.
Yes.
Where are the issues framed?
Issues framed
At para 5.
Para, yes, fine. Is the cause of action?
That's right.
Action for the present suit,
Roman 4 is the main issue.
the main issue.
Okay.
As plaintiff
How
right
the
placed
Roman
over
4 has
the
been
suit.
decided?
Now this is
What all were the exhibits?
Yes.
What all were the exhibits? Plaintiff.
Exhibit 2.
The same date that we disco in the year 1970.
This 1939 sale deed is what?
This is the
It is a
registered patta, registered settlement patta by way of which
In favor
I am
of?
claiming
In favor
in
of?
my favor. Should the disbanding
No, you were okay. You were the plaintiff, right?
Yes.
This is registered patta. Exhibit 2.
and basis of the retired recitals of this. Yeah,
This is registered patta post auction.
yes, Your Ladyship. Post op.
What is the date of auction?
As per this, Your Ladyship, 1936. Said auction was confirmed on 18/3/1935. The auction was confirmed and it was on 15 to 20. The said holding was auctioned, sold and purchased by the decree holder on 15 February 1935, and after the said auction was confirmed on 18th March 1935, and thereafter the landlord Raj Shiva Prasad obtained delivery of possession of the said holding measuring so and so on 14/9/1936.
So there is a registered patta of 1939.
39 that was executed by the Raja in my favor.
That's right.
That I have brought on record.
Then there is a subsequent. This is the base document.
Yes, this is the base
This is the
document.
base document.
And
What
was
about the
endorsed.
defendants?
Pardon me?
What about the defendants?
The defendants are saying that this auction was never conducted.
No, it's okay. They filed a rent receipt from which period?
Bishop, I have not been able to go to the lower court record.
Malguzari receipt,
Exhibit A series.
A series. This is the death certificate of whose? Exhibit B.
Bhagat Mohan.
When did he die?
$70 years ago he died.
1976. There is a death certificate. His father died in 1976.
Bhagirath Malla was his grandfather. Manik Malla's death certificate.
PW6 entered in the name of Bhagirath Malla. PW6 is who?
PW6 is
Bhumina Karmakar, plaintiff. One of the plaintiff.
And how is he related to Bhagirath Malla? Grandfather.
No, he is not. Plaintiff is not related to. Defendants are related.
Or defendants are related to.
Plaintiffs are related to Uday Karmakar. He claims
Yes.
to be the second.
Bishop Bhagirath Malla. His son was Manik Malla, and Manik Malla's sons are the defendants in the case.
That's right. Where is the finding?
I have summarized
Yes,
para
yes.
22.
They have discussed the evidences and then para 22. Kindly read para 22.
Since there are the main issues, issue number 2 and 4, the same are taken up for consideration first. The case of the plaintiff is that the recorded tenant Bhagirath Malla failed to pay arrears of rent, therefore the landlord filed a rent suit and obtained a degree. That
This decree has been exhibited? No.
no.
Further.
That the landlord also filed in execution case number so and so in the said execution case, the entire holding was auctioned, sold and purchased by the degree holder on 15/2/35. And the said auction was confirmed on 1935 that the Raja was in the possession of the land and executed registered patta dated so and so 28/2/39.
So they are claiming this title on the basis of a registered patta.
Yes.
Not, you forget about the execution part. On the basis of a registered patta executed by the Raja. Correct?
Yes.
So the finding of the learned trial court is, yes, continue.
And the auction confirmation is that Raja was in possession of the land and executed patta dated so and so, granted settlement of 66 decimals of plot number 1994 4 decimal and 62 decimals of 1995. Total area 66 decimal in favor of Uda Karmakar, the father and grandfather of plaintiffs, and they continued possession by paying rent to the Jamindar and after vesting the state. The basis of the title of the plaintiff is that rent suit. However, they have not mentioned the rent suit or the date of judgment. The execution case number so and so dated 15/2/35 and the date of confirmation dated 18/3/35 and the degree holder obtained possession on 14/9/36, but the said documents are not available with the record. In the absence of such document, the contention of the plaintiff cannot be accepted. This is the reason. The rent receipt filed by the plaintiffs are illegible. Plot number etc. was not there. The plaintiff have also not filed the Jamindari receipts of the scheduled land. The defendant have filed the Malguzari receipt which shows that the plaintiffs are paying the rent to the scheduled property. The plaintiff has stated that the predecessor bought the property from deed of settlement number so and so 28/2/39 executed by Raja Shivaprasad Singh by filing a rent suit against the recorded the year. No document regarding that or that is filed by the plaintiff. The plaintiff have failed to prove that from where their vendors had derived the title. The burden of
You see, there is a registered deed in their favor
registered deed,
of the
but
year 1939 executed by this Raja Shiv Prasad Singh.
Okay.
Right? And so far as you are concerned, you also say that Raja that the settle that you are that the you are the recorded tenant. That's right. Who was Raja Shiv Prasad Singh?
The ex-landlord.
Ex-landlord.
Yes.
So ex-landlord had settled the land in their favor on 28/2/1939.
Yeah, I don't dispute that there is no document of settlement.
Yes.
Settlement date, first I must lose the land, then he can execute a rent suit or the defaulter, rent suit can be declared, then it can be put in auction, then he can purchase and resume the property and then he can settle.
So do you want to say that this particular settlement patta dated 28/2/1939 is invalid?
The question is, it is a mere document, nothing else. If I don't lose the property, then anything recited in the deed.
No, forget about the recital.
Yes.
The point is that the ex-landlord has executed a deed
Yes.
in favor of the defendant, in favor of the plaintiff.
Yes.
Right? He has executed a deed in favor of the plaintiff. Once he executes a deed in favor of the plaintiff, what is the legal sanctity of that?
The legal sanctity, mere paper transaction, nothing else.
That is not your case.
Sir, it is my
Is there
case,
any
my
finding?
case that I am the recorded tenant. I never failed in payment of rent. I continued as a tenant, paid rent to the state, ex-landlord, then to the state, and continued possession as a successor of the recorded tenant. Now, where is the question of auctioning my property? In a rent suit, they said that in a rent suit, I defaulted, landlord filed a rent suit was declared, put in execution case, he purchased the property, resumed the possession through court, and then he executed the registered sale deed. All date shows that it was each dates are subsequent to that dates. Now, assume there are total, he is the landlord of entire Dhanbad state, district. So, what execution case, what property he has resumed? Now, unless it is clearly stated, either comes from the record that yes, this is the rent suit, this is the property resumed by the landlord. So, without any supporting document, right from the rent suit to the delivery of possession, mere execution of a sale deed, that does not extinguish the right of a recorded tenant. And that is the reason trial court has said that no document to show that we defaulted in payment of rent, execution was my property or land was put in execution, these lands are resumed by the landlord. All these plots must be corroborated from those documents. Otherwise, Raja Shiv Prasad Singh can execute any registered document of any property of Jharia to anybody once settled with a recorded tenant, and that without losing that right of recorded tenant, he again executes a registered sale deed. So what else is a mere paper transaction? Unless it is proved that this is the property
Your
sold.
Lordship, one important factor is that it is a registered document and it is a settled principle of law that a document is presumed to be genuine if it is registered. In my case, that is the sole aspect that has to be considered, Your Lordship. In fact, I have a Supreme Court latest judgment which says that.
Just a minute.
If you are sitting and then come to appellate court, how it is reversed. Taken note of all those facts, and one paragraph we reverse the judgment. And then paragraph 13 of the
Just a
appellate.
minute. Please hold. Yes, appellate court judgment.
Paragraph 13. Then page 14 of your report. On behalf of the defendant, respondent, the document filed on Exhibit A, series rent receipts. Exhibit B, certified copy of the certificate dated 29/3/90 of Malik Malla, issued by the CMO of Jharkhand mining settlement area. The parties are in dispute from much earlier this continuation it is written that Manik Mullah died on 1/3/90 and he was son of that Bhagrat Mullah. Exhibit C is the certified copy of the order dated 30th December 89 filed by Sri and Executive Magistrate Dhanbad in MP case number so and so. This case was filed initially under section 144 CRPC. The other side has not produced any witness and no document has been filed, hence it was ordered by the Executive Magistrate that Malik Mullah is in possession of the property. Exhibit B is the certified copy of judgment passed by the learned 4th Additional Session Judge number on 5/1/93 in criminal division number so and so. Munilal Karmakar versus Krishna Nishadar others. This case was filed against the order dated 30th December 89, passed by the London Executive Magistrate in MP case number so and so. London Court of 4th Additional Session Judge Dhanbad has been pleased to dismiss the division. Exhibit E is the certified copy of the order sheet with measurement case number so and so. Certified copy of the order dated 19/10/83 is Exhibit F on record. Earlier, the CI Sharia has given report to Circle Officer Sharia and mentioned that he was examining the petition given in by Manik Mullah, land comprising area of 2.91 acres under plot number 1993, 94, 95 and 15 and 10 under Khata number 42 of village Dumri was recorded in the name of Bhagirath Mullah, son of Budhan Mullah. On payment of annual rent of ₹3, which says Manik Mullah is son of Bhagirath Mullah, recorded tenant. Manik Mullah is paying rent for 2.25 acres of land of plot number so and so, and whether Uday Karmakar is paying rent for 0.46 acres of land of but Khata number so and so, plot number so and so.
So Manik
is not
Mullah is
mentioned.
paying rent for 2.25 acres.
Yes.
Manik Mullah is the defendants.
Yes.
Defendants.
Predecessor
So
of-
you were paying rent for 2.25 acres.
Yes.
And Uday Karmakar, the plaintiff, they were paying rent for 0.46 acres.
of land.
But Khata number and
Khata
plot number is
plot
not
number
mentioned.
is not mentioned. For which he is paying rent.
That's right. The case of the plaintiff
This
is,
is not mentioned how he is paying rent.
that's right.
The case of the plaintiff is that Raja Shivaprasad Singh has settled land to Uday Karmakar, who later on sold 20 acres of land to Tisco, and this document shows that Uday Karmakar is paying rent for remaining 0.46 acres of land. Munal Karmakar has filed M&A case number so and so in the court of AC Dhanbad. This case was disposed of on so and so with the direction to Munal Karmakar to show his document to Sharia Circle Officer. Certified copy of final record of live divisional survey operation is Exhibit G on record. On perusal of the same, find that it is related that plot number 1800, 1809, 16 so and so under Khata number 103, total area 4 acres 44 decimals. Exhibit H is deed number 1633 dated 29/174, executed by Uday Karmakar in favor of Tisco. Exhibit H1 is the deed number so and so dated 11/172, executed by Uday Karmakar in favor of Tisco. On perusal of the same, I find that by registered deed number so and so dated 29/174, exhibit H, Uday Karmakar sold 0.2 acres of land under plot number 1995, but out of total area of 1.23 acres under Khata number 42 of village Dumri, whereas wide registered sale deed dated 633 dated 11/1/1972, he has sold 0.13 acres land under plot number 1193 of Khata number 42 on consideration amount of so and so. It is not the case of the plaintiff appellant that the land of plot number 1193 was also settled by the ex-landlord in favor of Uday Karmakar. Now he is selling some other land and showing that this is the land I have sold it. If it is specific case of the plaintiff appellant that by registered settlement deed number so and so dated 23/2/39, 4 acres of under plot number 1194 and 062 acres under plot number 1995.
So what is under this registered settlement deed
Yes.
of 1939? What is the total area?
It is 66 decimal.
Just a moment. It was only this particular area which was claimed in the suit?
Yes. According to 39 deed, this plot number 1194
And 1995.
1995. Yes, sir.
What is the
What
what is the suit property? Just a moment.
This is the suit property. 44 decimal. They said that 20 decimal they have sold to this group.
Alright. And Uday Karnkar was found in possession of 0.46 acres of land.
They were paying rent for some state. Later on, his rent was not being taken by the revenue authority. The legal years of
One part has been skipped. The defendants have not filed any counterclaim to set aside the sale deed executed by Uday Karnkar in favor of Disco for land of plot number 1993, and this is not a subject matter of the suit. It came on record that Uday Karnkar was found in possession of 0.46 acres of land and he was paying rent to the state, which is important.
Later on, his rent was not being taken by the revenue authority. The legal heirs of Uday Karnkar have filed title suit number so and so for declaration of the realty right, title and interest over 0.66 acres in plot number 1994 and plot number 1995, corresponding to RS plot number 1809. They have admitted that out of 0.66 acres of land, they have sold 0.20 acres to Kisco. The specific case is that the recorded tenant Bhagirath Malla paid to in areas of rent. Then the landlord has filed rent suit and obtained the degree. Then he has filed execution case number so and so, and on 14/9/36 he has given possession of 2.91 acres of land of Khata number 42 of village Gundi by Collectorate Dhanbad. These facts are mentioned in registered settlement deed number so and so dated 23/3/39.
See, that is the only line, but these facts regarding rent receipt, etc., they were all exhibited documents. So he is finding.
The documents is not the all only it said this settlement deed is exhibited. Exhibit 2.
What about these rent receipts that
They
he was
were
discussing?
exhibited.
They were exhibited.
Yes, exhibit 1 your
So it is not a case that only on the basis of recital in the deed he is passing a judgment.
Rent receipt it is no plot number, no other number. What rent receipt is paying?
No, that is a separate thing. That is there. It is a part of the discussion.
A part of discussion, I appreciate, but evidence has to be taken into consideration in its entirety.
That's right.
If rent receipt does not disclose that this plot is rent, this rent is received for this plot.
So the point of law which has been formulated by this court, that whether the learned first appellate court committed perversity by considering that the recital made in the registered settlement deed marked exhibit 2 are conclusive proof of the title of the witness. Where is the finding that it is a conclusive proof?
Conclusive proof title or the vendor of the plaintiff.
Yes. Where is this conclusive proof? From where do you get this?
Conclusive proof of vendor's title, this says the conclusive proof. If they say produce the rent suit showing all the plots, that these are the plots for which I failed to pay the rent, then this suit is decreed for this plot.
And what about you? You produce the rent receipt from which period? Because that is not discussed anywhere. Neither in the trial court judgment nor in the appellate court judgment. Your rent receipt were for which period? Your rent receipts were exhibit?
Yes, it
exhibit A, public 6.
is. A to 6 and A7 to this one, 2 by different person. Malbuja receipt, Malbuja receipt. Exhibit G is the Khatiyan.
These Exhibit A series is for which period? Has it been mentioned in any of the judgments?
Para 16 of the trial court judgment.
Yes, let us see what is this Exhibit A series. What is the period of this Exhibit A series?
Government Bangladesh received dated so and so is written signed so and so.
So and so much पढ़िए भाई पूरा पढ़िए.
Para
So and so उनको समझ में नहीं आया.
EW1 in the examination.
Para number?
Para 16 of the trial court.
Para 16. Yes. Government Malgujari receipt of the year 1995.
95 is written and
Yes.
signed by Zoria Anshul.
That's right.
Adhikari Municipal
Then
Council.
another receipt of the year 1996.
96.
Then 99. There is no previous rent receipt. Where is it? You have not produced your old rent receipts. Not even one old rent receipt has been produced by you. And you claim that you are in possession of the property since beginning.
Khatiyan is Exhibit G.
Khatiyan is there, but apart from that, you have not proved that you were giving the rent from beginning.
State receipts.
Yes, this is just recent rent receipts you have produced. You have not produced your old rent receipts.
They were asked for cancellation of the sale deed also that have executed to.
That's right. In the year 1939, whatever, which had a cloud in your, which had a cloud with respect to your title.
Yes.
You never challenged that also. Did you?
Okay, this defendant remained in possession over the property unless my possession is also till date I am in possession. See, possession is not disturbed, some document created somewhere.
No, it has been created by the Raja, by the landlord.
Maybe Raja.
You see, anything you are continuing in possession, but once you come to know that with respect to your property,
Come to know that at what point of time, even in
any point of time, the moment you come to know, you can challenge.
In criminal proceeding, they didn't produce the document.
So it is a forged document.
Not forged document.
Then
Document is there, maybe there, but unless they assert title.
they are asserting title on the basis of that.
Title on from what date?
No, they are trying from 1939.
From 39.
Yes.
If they don't produce the
What you just tell us? What document have you produced
yes.
to show that you remained in possession of the property prior to 1995?
Right to
1995. That is the oldest rent receipt you have produced. And the judgment is not merely based on the recital of the sale deeds. They have the judgment has considered many other aspects of the matter also.
what are the other receipts?
आप देखिए judgment तो आप ही पढ़े.
Rent receipt, he says that the land has been settled. Now settled by Raja in 1939. He also not produced any document from rent receipt from Raja. his document also state government rent receipt, no plot number, no khata number is mentioned. So only one sale
It's a
deed,
registered patta. You can't
registered
ignore
patta, I
it.
say.
Yes.
Registered patta, then land.
Then followed by,
Now,
just a
if
moment,
I execute a patta,
then
now,
followed by subsequent sale deeds also, and one sale deed.
subsequent sale deed, third party sale deed.
Just a moment, just a moment. And followed by one more sale deed in regard to one TISCO matter.
And that says that he sold another different plot. Appellate court judgment you will also receive. He sold a different plot. That is the said that 1911, 93. The sale rate so and so, the land address so and so. Now this 1194, 1995. Now 1193 was not settled with him. Now he sold 13 decimals of that land. So what type of person is he? He is. Now he sells some different land and says that I have sold this to TISCO, so deduct 20 decimals and then declare 46 decimals.
This 20 decimal was not a part of the land which was involved in the deed of 1939.
No, that part 20 was part of the 66 decimal was settled.
Yes.
According to their case.
Yes.
They say that 20 decimals sold to TISCO.
Yes.
And 46 decimal remained with
Yes,
them.
20 decimal.
Now he produced a different sale deed.
No, let us see what is the finding in connection with 20 decimal of land.
The 20 decimals, there is nothing. Only said that he said 20 decimals deducted, sold to TISCO, that's why 46 decimal degree was allowed.
Yes.
There must be consideration that these are the sale deed, these.
No, you say that this 20 decimal of land was not sold to TISCO, or the land which was sold to TISCO was not a part. Was the land which was sold to TISCO not a part of the sale deed of 1939?
That's what the courts, appellate court also taken into consideration.
Where is that consideration?
There he says that 1193 was sold. This is not 94, 95 is the second land. So
Where is it? Where is it? Appellate court?
Page 16, 6, 7 line below from top. Whereas the registered sale deed dated.
8 seconds, let me be there.
This was sold in 1972. TISCO we have sold in 1974. That is another plot of land that they discussed.
Another plot of land, what is the document? Where is that consideration that this is the land sold? He sold 1193. Khata number which was not settled with them. It is not the case of the plaintiff appellant that the land of plot number 1193 was also settled by the ex-landlord in favor of Udaka.
Prior to that, on perusal of the same, I find that by registered deed number 1633 dated 29th January 1974, Uday Karmakar has sold 20 decimal 0.20 acres of land, plot number 1995, out of total area 1.23 acres under Khata number 2042 of village Dumari. And thereafter he has sold some other 0.13 acres which we are not concerned about. But 0.20 acres out of 1995 plot number, which is the subject matter of this case.
Exhibit H.
Exhibit H.
Total area of 1.23 acres, 66 decimals settlement near 1.23
Exhibit H, what do you say to this? Exhibit H.
This is their document that they have plot number for.
What is the date of the sale deed?
Sale date is 29th January 1974.
Plot number 1991. It is there in the deed also.
And they have brought this document on record.
Mozart 111, Khata number 42, plot number 1992. Area 1.23 decimal, out of which 20 decimal. This sale was out of this property. And Uday Kankar was found in possession of 0.46 acres of land. And the claim was in connection with 0.66 acres of land.
Out of 6.
So you were in possession only, that was your specific case, that you were in possession only in connection with 0.46 acres of land. Not more.
No, 46 is plenty space. I have 2.91 acres. Total out of 42.
You just see the appellate court judgment. It came on record that Uday Kankar was found in possession of 0.46 acres of land and he was paying rent to the state.
Yes, that is only, it is plaintiff's case. My case, defendant's case, defendant is recorded tenure of 2.91 acres of land.
And you were paying rent for 2.91 acres of land.
Yes, that's
Where
why
is that finding? Where is that finding?
That's why his rent was not accepted lateral.
You see para number 13 on behalf of the defendant. Para number 13 of the appellate court's judgment. Banik Malla is paying rent for 2.25 acres of land in plot number 1510/2208, 1993 and 1995, whereas Uday Kankar is paying rent for 0.46 acres of land, but khata number and plot number is not mentioned. It is not mentioned how he is paying rent. Para number 12, he records that Exhibit 1 series are the rent receipts in the name of Uday Kankar issued in Jamabandi number 88. And Exhibit 2 is the certified copy of the sale deed of 1939. The sale deed of 1939 is relating to Jamabandi number 88.
No, initially it was, I'm not, the record of right change, that is the reason record changed. Khata has been changed.
So this Jamabandi number 88 is related to this property. In whose favor the order under section 145 and 144 CRPC was passed?
That was in my board, account of to criminal code.
So you were found in possession of the property.
But your ladyship, it is a categorical finding regarding the divisional code saying that the other side has not produced anything and no document has been filed, hence it is ordered by the executive magistrate that Manik Malla is in possession of the property. Because we could not reduce evidence, they have gone ahead and declared their possession of the property, which is a categorical finding. Our claim of possession and title is based on a registered patta deed.
Is there
That
any
has
finding
never been
on possession? Is there any finding on possession?
They have not even challenged the sale deed that we have executed to the disco.
Is there any fine? Merely because there is a sale deed, that does not mean that you are in possession of the property. Is there any finding on possession?
Suit for recovery of possession presumption. They have admitted that I am in possession.
No. And in alternative.
And in
It was an alternative plea. Is there any finding of possession?
Issue was also not there.
It came on record that Uday Karmkar was found in possession of 0.46
No, in
acres and
record
was
that
being
is a
read to
separate
the state.
thing. Just a moment.
Yes.
I find that the plaintiff appellant have their right title interest over 0.46 acres of land of CS plot number such and such, under khata number such and such. Hence I file and hold that the judgment and decree is set aside. Correct?
Yes.
There is no decree for recovery of possession.
Yes. No recovery. So contrary to that,
There is no decree of you just live with your title. There is no decree of recovery of possession.
we have been paying rent here, continuously. It was
That's right, but there is no decree of recovery of possession.
Yes, that has not been granted to us. We have been granted right, title, and interest in the property. A separate suit will be filed by us if we do not have possession, your ladyship, or if the possession is disputed. Since there is no dispute regarding possession, we have not prayed for it and asked for it. Otherwise, we would have been aggrieved and filed an appeal against that.
What is title suit number 114 of 2003? Oh, this is the title suit.
Yes. 2003 we filed it only because they stopped taking rent from us.
It is a original title suit. They are fine. Against that, this appeal is flexible.
There have been two MP cases. One is MP case number 1797 of 2001. Other is MP case number 1091 of 1982. 1091 of 1982 was also decided in favor of the defendant, and MP case number
mention of MRA case number in which is 38 30 1983.
it is not MRA case. There is 1983. What is it all about?
Where it says that Munilal Kankar has filed MRA case number 30/83 in the court of AC Dhanbad. This case was disposed of on 29/10/1983 with a direction to Munilal Kankar to show his document to Jharya C. That is all.
So ultimately, what happened? It's not there.
And that too, it was with respect to some other
You
plot
see
numbers.
internal page number 4 of the trial court judgment. It talks about MP case number 1091 of 82 decided in favor of the defendant, and internal page 5 talks about MP case number 1797 of 2001 again decided in favor of the defendant. There are two proceedings under section 145, both decided ultimately in favor of the defendant.
In the first case, Your Lordship, we were never allowed to adduce any evidence. So therefore, it was decided in his favor, which is a categorical
So
finding.
whatever be the reason, but in both the cases,
The second case, Your Lordship, was decided in 2002, after which we have filed the instant title suit. Regarding the possession, in their written statement they had said that we have taken possession from them, and it is come on record also that in reply to the allegation made in para 12, it is stated by the defendants that they are in peaceful possession of land, and plaintiffs with the help of local police and other leaders and gundas are trying to take possession of the land of the defendant, which is already fenced by bushes and shrubs.
let us read the point number 1 by the appellate court. That is at internal page 10. Let me read it.
Well, London first appellate court.
Where is the record? Para number 10 of the appellate court's judgment.
Point number 1.
Yes.
Where is the record? Munilal Karmukar and Manesha Karmukar claim the suit property on the basis of their being heirs and successor of Uday Karmakar. As per the case of the plaintiff, Uday Karmakar got 0.66 acres of land through registered patta dated so and so from Raja Shivaprasad Singh, who got 2.91 acres of land on 14/9/36 in execution case number so and so, arising out of the rent suit, when the recorded tenant Bhagirath Molla failed to pay rent to the landlord. On the other hand, defendant have put forward the case that Raja Shivaprasad Singh never possessed the suit property. The suit property was never auction sold. No settlement was made by ex-landlord Uday Karmakar. Rather, the recorded tenant Bhagirath Molla was all along in possession of the suit property, who died leaving behind his son Manik Molla and his widow, wife of Bhagirath Molla. Munilal Molla is in possession of the suit property. As first I have gone through the oral evidence of record, Damodar Prasad Jubel so the formal witness was proved the rent receipt exhibit 1. Ram Prasad Pandey, PwC is another formal witness to prove the rent receipts exhibit 1 by B. Dhananjay Mahato, PwC has stated about the case of plaintiff in his examination in chief, filed on affidavit and further stated that he cannot say about the khata number and plot number of the suit property. He has not seen any document. Father of Munilal got the suit property from ex landlord. He does not know Bhagirath Molla. He does not know about the details of the property party. He cannot say why Uday Karmakar died. When Uday Karmakar died, he admits that the suit property was measured. Pran Mahato PW4 has stated that he cannot say about the plot number of the suit property. He cannot say about the name of grandfather of Munilal. In plot number 1994, there was 0.4 acres of land, and plot number 1999, there is 0.62 acres of land. He cannot say about the measurement of the land. There are two shops in the suit property. Munilal Karmakar PW6 is the plaintiff number 1. He has filed his examination in chief on oath and further stated that his house is situated about 300 meters away from the suit property. There is flag of Tata Company nearby the suit property. The rent suit was filed prior to his birth. The execution was filed in collected Dhanbad Ministry so where the witness all are dead. The ex-landlord has given the land to his father through registered deed of settlement, but he cannot say who has written. He has filed original deed of settlement in the court. He cannot say who has prepared the registered settlement deed. Earlier there were cases filed between the parties under section 107, 144, 130 of CRPC. Shivaprasad Singh has filed this case number 664. When the land was measured, he was present there. His possession was found. In the year 2003, he has filed suit for injunction on the court of landed Munsi. He admits that the divisional survey record of right is prepared in the name of Ram Khelan, Krishna Malla and Vijay Malla. He has also admits that the recorded tenant of khata number 42 was Bhagirath Molla. The new plot number so of suit property is 1809. His father was mutated for the suit property. Presently, CEO Zodia is not taking rent from them. He got no notice for the same. Bhagirath Molla had no son, rather he had only one daughter. He has stated about revenue cases filed with SDO number. He admits that prior to 1922-23, Bhagirath Molla used to give rent to the landlord Jagdish Mahato PW5 has stated that father of Munilal Karmakar was in cultivating possession of the suit property. The road was constructed on plot number 1994-95. Tata Company Maniklal Karmakar was working in Jitpur Colliery. The road construction of Tata Company passes through the suit property. Bhim Chandra Mahato, PW7 is formal witness who has proved the rent receipt. Surendra Prasad was appointed an advocate commissioner and has found two constructed rooms on the suit property. Baneshwar Karmakar, PW8 has stated that his grandfather Uday Karmaka died in the year 1974. They are in possession of the suit property since 1949. Bhagirath Malla was not grandfather of Ramkilan Malla. He cannot say how many times the suit property was measured. He cannot say about any suit filed under section 87 CNT Act. One measurement case number so and so was filed because she was area by Manik Malla. He does not know that Amin has measured the land in presence of both parties. On behalf of the defendant, the witness examined are Guneshwar Singh, DW1, was proved plaintiff. He is formally witness DW2. Prakash Thakur stated about the case of the defendant in his examination in chief, filed on oath, and further states that the defendants are working with him in Tisco Washery. He has no concern with the suit property. He had seen the document related with the suit property, but he cannot say who was prepared the same. He cannot say about the boundary of the suit property. The road passing through suit property is constructed by the government. Bhagendranath Mahathur declared 3 is formal witness, was proved plaintiff. Krishna Prasad Nishad Molla declared proves the defendant number 2. He has stated about his case in his examining chief filed on oath. He further states that he does not know about any rent suit. His grandfather Bhagirath Molla used to give rent to the ex-landlord. He categorically denied the rent suit number so and so was filed by the ex-landlord. He has not gone through the documents filed by the plaintiff. The preliminary record of right was prepared in their favor, which he has filed in the court. Ram Khilawan Nishad, PW5 is defendant number 1. He had seen the document filed by the plaintiff, but he has not filed any counterclaim. He admits that there is 2 rooms, house of plaintiff on the plot number 1997. He cannot say what is written in the plaint. He has no objection if the survey going advocate commissioner will file the report in court. Produce document exhibit 1 series of the rent receipt in the name of Uday Karmakar issued in job order number 88. Exhibit 2 is a certified copy of the registered patta so and so, dated so and so. On perusal of same, I find that Rajesh Chaturvedi Singh has executed registered settlement in favor of Uday Karmakar, son of Hariram Karmakar, as Rayati Road Patta for khata number 42 under plot number 1 of village Pindi under plot number 1994 0.4 acres and 1995 0.62 acres, total 0.66 acres, the specific boundary. It is written in that deed that by execution case number so and so, he has purchased the property in auction sale, and after that he has settled the same through aforesaid registered deed in favor of Uday Karmakar. Exhibit 3 is the certified copy of registered deed, sale deed number so and so, 29/74 by Uday Karmakar has sold 0.20 acres of land to Tisco. Exhibit 4. Certified copy. Exhibit 4 is a certified copy of judgment passed by London's 5th Additional Session Judge Dhanbad in criminal division number so and so, arising out of application number 1779/1, Ram Khilawan Molla and others versus Manusha Karmakar and others. This revision was filed against the order dated 2/2/2002, passed by Sri so and so, Executive Magistrate Dhanbad in application number 1779 of 2001, whereby the case was converted into section 140 of CRPC. The revision was allowed. Exhibit 5 to Exhibit 8 are documents related with measurement of the land by survey inferior commissioner. On behalf of the defendant and the respondent, filed Exhibit A series, the rent receipt, Exhibit B, so and so. Is under 30.
There is no finding that the plaintiff is in possession of the property. There is no finding in connection with possession at all. There is no decree for delivery of possession. It's not there.
Our prayer was also for title relation on the
No,
basis.
no, no. You also prayed for in the alternative if you are not
In the
found in
alternative
possession.
relation. But right title and interest was a primary prayer relation which was allowed on the basis of the registered deed. The substantial question of law was also framed to that extent. And they have never challenged any of the deeds that has been
They claim
filed.
possession.
They only are claiming possession, and that too they have filed rent
No,
receipts
they
only
are
94.
They are not only claiming possession, but there are records. The recorded entries are there that they are in possession of the property and they are the descendants of the recorded tenant. That is also there.
Yes, Your Worship, but no document has been brought to record prior to 94, Your Worship. Rent receipts also they have filed only post 94. They have only made one statement
But
claim.
the entry in record of rights is there in their name.
Exhibit 0 Khatiyan is there.
The Khatiyan is in their name.
They have also.
If you are claiming rent receipt, where is your mutation and where is your entry in the record of right? There is no entry in the record of right. And you have not proved anything about the auction, etc. Nothing.
Your Worship, the deed itself belongs to 1939 and it is a
So
settled
there,
principle of law.
no. Just a minute. Their case is that they are the recorded tenant, they are in possession of the property. Their further case is that the vendor of yours, the landlord, never came in possession of the property, and this deed of yours is of no use.
It's a registered deed, Your Worship. They have
Every
not been asked
registered
for
document is
cancellation.
not a gospel truth because you claimed that you got that property through auction sale, and this auction sale etc. has not been proved by you, not at all. It is only recited in your sale.
But Jamabandi number of 88 is there, Your Worship.
No,
As per-
Jamabandi number, we are not able to find out how this Jamabandi number 88 is coming into picture. But there are other documents also. There are two proceedings under section 145 in their favor. The record of rights also show that they are the recorded tenant. If their if the tenancy was cancelled on account of non-payment of rent, appropriate entries ought to have been made in the record of rights. There is no corresponding entry in the record of rights to enable you to pay rent.
When you don't peruse the records,
We are hearing you for more than an hour. You say that you have not perused the
maybe
record
passed
of
away relation. Only Jamabandi 88, if we can see a relation, if the relevant plots of land have been mentioned in that, then it shows that yes, I have been paying the rent for a long
Jamabandi
time.
88 is which exhibit?
Your Worship, we have, there's a categorical finding in the appellate court's order, Your Worship, which discusses Jamabandi 88,
With respect to which exhibit?
and subsequent to that we have been
Which
paying the
exhibit?
Malkazari rents mention that, Your Worship.
Which exhibit?
Peruse the documents Exhibit 1 series are the rent receipts in the name of Uday Karnkar issued in Jamabandi number 88.
Exhibit 1 series, right?
Yes, Your Worship. The rent receipts.
It is only Jamabandi number 88, nothing is mentioned. You can have a look.
Initially, suit filed with regard to dot number 1994 and 1995, order number 42. Now the coordinate suit was number 88.
Sorry?
Job number 88 is said, but neither it is the list of documents exhibited.
Yes, these are the, you just have a look at this.
These are the rent receipts.
Yes, it is not referring to any plot number. It
I
is
am saying
referring to
really-
Jamabandi number 88. In your entire claim, nothing has been mentioned about Jamabandi number 88.
According to me, my understanding is that that should not be of much relevance because at the end of the day, Jamabandi or Register 2 are not documents of title. It are at best documents of possession. Who's going to pay rent?
Just a moment, let us see this. There are two parallel claims. One is of the recorded tenant saying that his name continues in the record of rights and he is in possession of the property and he has been paying rent. The rent receipts are from 1995, the old rent receipts are not. But his name appears in the record of right, this is also an admitted fact. That record of right, whatever be the entries, no petition was taken out under section 87 of the CNT Act. That entry in record of right became final. Now your case is that the Jamindar, his further case is that Jamindar never came in possession of the property. And you say that there was a rent suit, he defaulted and there was an auction, and pursuant to that auction you purchased that property and ultimately the sale deed was executed by the Raja, by the Zamindar, right? Firstly, let's take it. Then, but you have not produced any document regarding to his default, the rent suit. So therefore, there is parallel right. His case is that if his right is existing, there is no question of creation of any pattern.
Can I just answer that? If I have a registered document in my hand and that I have proved it was validly registered, then there is a presumption of genuineness, number one. The presumption of the document which we are relying upon are on two folds. One, of it being registered, and number two, it being older than 30 years. That to rebut that presumption, the onus was on them.
No, that's right. They do not say that the document was not executed.
Correct. So
Right.
therefore,
But the point is, they say that there was no such proceeding to cancel their.
that they can't. Therefore, the rebuttal, the contents of the document also stands proof. That's the point.
How do
The
you
question-
say that merely because the document is proved, the contents of the documents also is
This
also
document is presumed to be valid and the contents, therefore, the document, but the existence of the document.
under which law the contents of the
Have a
document
look at
stands
the
proved?
presumption of genuineness of the document.
No, that there is no doubt that there is a presumption that the document was executed.
Correct.
But the recitals which are mentioned in the document
That is
also
also
stands proof.
Section
How do you
91, 92
You
of the Evidence
see,
Act.
yes, that the contents of the document is
No,
also
no,
proved.
if someone is going to go against the contents of a written document, then oral evidence is also not sufficient. Then they have to prove something more.
Okay.
It's the best evidence rule is documentary evidence. Section 91, 92 of the Evidence Act.
Yes, read it.
Just
First para 90. 90.
Just
89 and 90.
of the Evidence Act.
Yes.
Just can you give me a minute? Presumption as to due execution of documents not produced. The court shall presume that every document called for and not produced after notice to produce was attested, stamped, and executed in the manner prescribed by law. Presumption as to documents 30 years old. Where any document purporting or proves to be 30 years old is produced from any custody which the court in the particular case considers proper
the court may presume the signature and every other part of such document which purports to be in the handwriting of any particular person in that person's handwriting, and in the case of a document executed or attested, it was duly executed and attested by the persons by whom it purports to be executed. And
This is
attested.
in the case whether it is called for from a custody.
No, 30 years old. This
No,
is section.
not only this. When any document purported to be proved to be 30 years
30 years,
is
it's only
produced
30.
from any custody of the court.
Custody which the court of a particular case considers proper. That is, it can be my custody also.
Is produced from any custody which the court in particular case considers proper.
Explanation.
Suppose the court says that you produce this document from such and such
Not
place.
necessary. Can we see explanation?
Yes.
Documents are said to be in proper custody if they are in place in which and under the care of the person with whom they would naturally be. But no custody is improper if it is proved that to have a legitimate origin, or if the circumstances of a particular case are such to render. So if it is my document, I produce it, the presumption will apply.
You read the illustration A. Illustration
A has been in possession of a landed property for a long time. He produces from his custody deeds relating to the land showing his title to it, the custody's property. So in my case, not the explanation one satisfies the requirement. But so this merit is one. Number two, your lordship will see section 19.
A has been in possession of the landed property. So you claim to be in possession of the landed property. There is no decree for recovery of possession.
That's good.
But there is no finding also on possession. There is no finding on possession.
Very good.
We have gone through the entire judgment. There is no finding on
There is no
possession.
finding by.
Nor you are agreed by that.
I have
Because
not seen to be agreed by any portion. So the possession is not a dispute so far as I am concerned. But I get lost, do not complain now. So this merit is a presumption. There is another presumption which I want your lordship to see. Section 91. your lordship.
91.
Yes. Evidence of terms of contract, grants and other dispositions of property reduced to form of a document. When the terms of a contract or of a grant or of any other disposition of property have been reduced to a form of a document, and in all cases in which any matter is required by law to be reduced to the form of a document, no evidence shall be given in proof of the terms of such contract, grant or other disposition of property, or such matter except the document itself, or secondary evidence of its contents in cases in which secondary evidence is admissible under the provisions of hereinafter. So this is the provision which says that if the document is proved, no other evidence is required.
So your case is if there is a registered document, not only the registration of the document but also the contents.
It stands proved.
It stands proved.
Unless section 90, section 92 also excludes oral evidence from disputing the contents. Kindly look at section 92. Exclusion of oral evidence, exclusion of evidence of oral agreement, where the terms of any such contract, grant or other disposition of property or any other required by law to be reduced in the form of a document have been proved according to the last section. No evidence in the form of oral agreement or statement shall be admitted as between the parties to any such instrument and their representatives' interest for the purposes of contradicting, varying, adding or subtracting its term. So therefore, even the parties cannot lead evidence.
So therefore, your argument that the contents of the document has been rightly taken into consideration by the appellate court to come to a finding that there was this background so far as the sale is concerned, and it is further not in dispute that you are claiming through that.
Right. Now, in the context of this, if you lordship looks at the substantial question of law framed while admitting the appeal, my argument in terms of section 100 subsection 5 is in view of section 90 of the Evidence Act, the question is whether the learned first applicant committed perversity by considering the recitals made in the registered settlement deed marked.
This is covered by
section 90. Now, therefore, I say come and have a look at section 100 subsection 5 of the CPC. I think it is 100 subsection 5. Now therefore, the appeal shall be heard
That's
on the
right,
question.
we are not on.
No, I am only saying that as a respondent, last portion, be allowed to argue that the case does not involve such question, provided that nothing in the substance deemed to take away or breach the power of the court.
Whatever it is, that is a
That is
substantial
what?
question of law which has been
I
framed
say
in
what
your
it is not a-
absence. You
yes.
say that the
It
it
is
is
not a
covered by
substantial
the.
question.
It is not a substantial. It is covered by this.
I have a further point. The further point is that once you come to know about the existence of a document which is coming in your way of title, then if you are party to the document, then you seek cancellation of the document. If you are not a party to the document, then you seek a declaration that the document is void or document is not binding on you. But the declaration is a must. If a document is shown at your face, then you cannot, in order to
It cannot be. It cannot become nullity
by itself.
by itself.
By itself. Because now why cleverly this is not done? Because you know that it is my challenge is time bound.
Not necessarily. He may say that I am in possession. I had no idea about it.
Correct.
I had no knowledge about it.
He had no knowledge about it. Very good. But the point is that he has to prove that he had no knowledge. That's the point. He will have
No,
to.
once he says that he has no knowledge, you will have to prove that he has knowledge.
Correct. If I am able to
Because
show.
negative evidence cannot be led. If I say I have no
But
knowledge,
if
I simply say that I have no knowledge.
But now.
But that is not the matter here.
That is not the matter.
That is
So I
not the
say
matter.
the question of law stands answered in by section 90 of the Evidence Act. And
Do you
it's
have
not
to
a
say
substantial
anything more?
question.
Section 19. This 30 years old document, presumption is there. Some presumption is there, but to what extent presumption? Where any documents?
Can I just end my thing by citing a judgment? Sorry, वो मेरा copy. Sorry. Para 32 notes, page 27. Para page 27.
Yes, and
To appreciate the findings arrived by the courts below, we must first see on whom the onus of proof is. The record reveals that the disputed documents are registered. We are therefore guided by the settled principle that the document is presumed to be genuine if the same is registered, as held by this court in Prem Singh versus so and so. The relevant portion of the said decision reads as follows. There is a presumption that a registered document is validly executed. A registered document, therefore, prima facie would be valid. The onus of proof thus would be on the person who leads evidence to rebut the presumption. In the instant case, respondent number 1 has not been able to rebut the presumption. In view thereof, the present case, the initial onus was on the plaintiff who had challenged the stated registered document. To me, I am only on that paragraph principle that there is a presumption and the onus lies on them to show. I am not required to show that the contents are right. It will be presumed to be correct in view of section 90. Otherwise established, they will have to lead cogent evidence to rebut that no, there was no such, a case number is given, certified copy of the case number would show this land is not involved. These are the steps the defendant had to take.
you respond?
Section 19.
Yes.
Presumption as to documents 30 years later. Where any document purported or proved to be 30 years old is produced from any custody which the court is in the particular case considers proper, the court may presume that the signature and every other part of such document which purports to be in the handwriting of any particular person is in that person's handwriting, and in the case of a document executed or attested, that it was duly executed and attested by the persons by whom it purposed to be executed and attested. But what are the presumptions under section 90 of the Evidence Act?
To the extent it is handwritten.
Extent.
And maybe that person will not come to adduce evidence. But not the entire recital.
Entire document, now something quoted. He says that if there is a rate suit, there is a degree, then degree was put in execution, in execution there is auction sale, and in auction sale purchase, then on purchase of auction sale, delivery of person was given to him. So all these are based on the document of court. Now these are recited in the same deed. Now
all these handwriting, signature, these are the person's document. These are 30 years old. Some presumption is there under section 90, but it does not say that whatever wrong thing has been written as a covenant in the sale deed, that will be also presumed to be correct and genuine.
You see, this in 19 this 30 years old document.
Yes.
I'm sure it is not a type. It is a handwritten document. No, it is a handwritten document written by somebody.
Somebody.
Right? Then under such circumstances, that handwritten document is presumed under section 90.
90, his signature, handwriting,
Yes.
execution, attestation.
Yes.
Who has attested it?
Yes.
Attesting signature.
And every other part of such document which purported to be in the handwriting of any particular person is in that person's handwriting. Nothing more.
Nothing more. It does not create that whatever written in the
is itself
deed,
correct.
It is presumed to be correct. And exhibit G, that is record of right, Khatiyam, which stands all along in my name or the name of my predecessor. Then unless there is a deletion or some correction in the record of right, so I am there in the record of right all along. Now how my right will be extinguished?
Just a minute. For the learned counsels appearing on behalf of the appellants, this appeal has been admitted by the order dated 26/7/2023 on the following substantial question of law. The learned counsel for the appellant has submitted that the appellant is claiming the property. The appellant is a defendant. The judgment is of reversal. The learned counsel has submitted that the appellant is the descendant of the recorded tenant whose name has been duly recorded in the record of rights. He has also submitted that the entries in the record of right has become final and there is nothing on record to show that such entry was ever challenged. The learned counsel has also submitted that there were two proceedings under section 145 of CRPC and in both the proceedings the plaintiff had lost. The matter attained finality in the 145 proceedings only at the stage of revision. The learned counsel has further submitted that the suit was dismissed on the ground that the basis that the plaintiff failed to prove the basis of the title, inasmuch as the basis of the title of the plaintiff is the rent suit, but they had not mentioned the rent suit or the date of judgment. The execution case number 664 of 1933-34 dated 15/2/1935 and date of confirmation of sale dated 18/3/35 and the decree that the decree holder obtained possession on 14/9/1936, but no such documents were available on record. And in absence of such documents, the trial court refused to accept the contention of the plaintiff. The learned counsel submits that the judgment of the trial court has been reversed by the appellate court primarily by referring to the contents of the registered sale deed dated, date बताइए, sale deed number
664.
sorry, sale deed number
Registered Patta deed number 544 dated 23rd February 1939.
लिख लिए हाँ The learned counsel submits that the appellate court has erred in law in reversing the decree by referring to the recitals of the sale deed, of the deed. He has also submitted that merely because the deed is registered, the same does not mean that every recital mentioned therein is also correct. He submits that the fact about auction, execution and possession was also required to be duly proved. He submits that it was a specific case of the defendant before the court that the vendor of the sale deed, the ex-landlord, never came in possession of the property, and therefore the record of rights reveal that the name of the ancestor of the defendant find place therein. The learned counsel appearing on behalf of the respondents, on the other hand, while opposing the prayer, has submitted that the learned appellate court has rightly referred to the recitals made in the registered sale deed. He has in particular referred to Section 90 of the Evidence Act to submit that the entire deed, not only the execution of the deed but also the contents thereof, is presumed to be correct. He has further submitted that he has further referred to Section 91 of the Evidence Act to submit that when a term of contract or a grant or any other disposition of property have been reduced in the form of a document, and in all cases in which any matter is required by law to be reduced to the form of a document, no evidence shall be given in proof of the terms of such contract, grant or disposition of property or such matter except the document itself or the secondary evidence of its content in cases in which secondary evidence is admissible under the provisions contained prior to that section. The learned counsel submits that the recital of the document of the registered sale deed has been rightly taken care of by the appellate court to reverse the decree. In response, the learned counsel for the appellant, the learned counsel for the respondent has also relied upon the judgment passed by the Honorable Supreme Court in Civil Appeal number 3681-3682 of 2020, Ratan Singh versus Nirmal Gill and others, dated 16th of November 2020, in particular paragraph 32 thereof, to submit that it is settled legal principle that a document is presumed to be genuine if it is registered. And further, in the same case, a reference has been made to the earlier judgment of the court in the case of Prem Singh and others versus Birbal Singh and others, reported in bracket 2006 bracket close 5 SCC 352. He has submitted that the initial onus was on the defendant who had challenged the registered document. The learned counsel has also submitted that there is another aspect of the matter, in as much as the defendant had never challenged the sale deed of the year or the sale deed pursuant to which the plaintiff was claiming right, title and possession. But that is not the question of law framed.
No.
That is not the question.
No, that's not a question, but I am answering.
Although no question of law as such has been framed in connection with the last argument of the learned, last point of argument advanced by the learned counsel for the respondent. In response, the learned counsel for the appellant has also referred to section 90 and has submitted that that not every matter mentioned in the registered sale deed, which was in a document which is 30 years old, is to be taken to be a gospel truth, but the court may presume that the signature and every other part of such document which purports to be in the handwriting of any particular person is in that person's handwriting. And in the case of a document executed or attested, that it was duly executed and attested by the persons by whom it purports to be executed and attested. The learned counsel submits that essentially the presumption is in relation to the execution of the very document, but the same does not presume, but there is no presumption that every recital mentioned therein is correct. He submits that the recitals of the registered document was required to be proved by the plaintiff, which the plaintiff admittedly did not prove, and the appellate court has taken the recital of the registered deed as gospel truth and has reversed the decree. That's all. Arguments concluded. छूटा नहीं ना आपका? Just a moment. एक आध पीस और भी डाले हैं. ये सारा अपडेटेड है. डेट नहीं रहने से ना मिस हो जाता है. मार्च का कोई डेट दीजिए ना. होली के जस्ट पहले का, होली की छुट्टी के जस्ट पहले का.
Holi this time is kind of with problem.
It's a vacation.
It's only 2 days.
2 days.
It's only 13th, 14th holiday, 15th, 16th Saturday, Sunday. So we have 4 days.
That's
so
all.
10. That's all. Holi is the matter. So I am only requesting please do not have it on 10th, 11th, 12th notes because I may not.
It will be a judgment.
Your judgment.
No, it's all concluded. I give a date on the judgment also, such that there is some pressure on me also that it has to be delivered on a particular date.
Just before Holi is 10th, 11th, 12th.
10th, 11th, 12th. We'll post it on 10th ko Monday hai?
Monday.
11th for judgment. And while I deliver the judgment, I just record the last heard on sentences. This is how it is. CAV होने से वो इतना काम के प्रेशर में क्या होता है कि वो बैक सीट में जाने.
As a request, tomorrow most likely would have heard that there is going to be a reference in this area. Okay. Now your lordship has fixed a civil petition for hearing tomorrow, in the second time.
I have fixed it.
Yes. So Mr. Sudipto Sarkar was supposed to come, but I am asking him to not come tomorrow because there is a reference. He may only join online for a few minutes if your lordship wants to get an idea about what it is.
For what? No. ऐसा नहीं. Adjournment चाहिए तो adjournment. Joining for 2 minutes का कहानी को चले.
हमको कुछ नहीं, हम लोग तो पूरा तैयारी के साथ है. 2:15 फिक्स्ड है. अगर आप सुनना चाहेंगे सुन
नहीं, आप जो भी आएगा next day आप अपना date बता देंगे.
I'll ask him to join online and make a request.
Not required.
We'll be here for a date.
Not required.
No, for a date. For a date.
Yes, you just mention it that it is at 2:15. It is not going to be taken up because of reference. So I'll just you can get your choice date from the court master. You don't need to even mention.
I need to consult the other side and on this.
हाँ तो consent date एक तो slip में डाल के दे दो.
You already said.
Yes.
This was serial number 14. I was on legs in the court.
आपका केस dismiss कर दिए.
Serial very.
Sorry. तो क्या करिए आप लोग तो कितना बार आपको नाम फ्लैश किए, आपको इनविटेशन कार्ड भेजे, आपको सब कुछ dismiss हो गया ना?
Instead of dismissing your achievement, hear it or make it.
लेकिन हम लिखेंगे फर्स्ट हाफ में आप, लेकिन अदर साइड कहाँ उसको लेके आइए.
नहीं तो it is for admission.
It is for admission.
No, not yet admitted.
अब देखिए सेकंड हाफ में कितना हो सकता है. एक मिस्टर साहनी का इतना छोटा सा मैटर था, पास ओवर करा दिया. नहीं आप आइए मिस्टर साहनी, वी हैव टू डिस्पोज ऑफ दैट. आप हम एकदम 2:15 बजे डॉट आ जाएंगे, 2:15 एट डॉट. ठीक है. अदर साइड कौन है आपके केस? उनको इन्फॉर्म भी कर दीजिए भाई नहीं भी. द ओनली थिंग इज that you have to your right to go for alternative. That's it.